We continue to read the case of Roy Dessado versus Jennifer Brown. This is a case that falls under the Rights of Spouses Act, which includes an application for share in a property after the end of a common law union. Analysis. The Property Rights of Spouses Act seeks to extend protection to both men and women in common law unions who would otherwise be left without an interest in the premises they occupied as a family. Section 13, subsection 1A provides that a spouse shall be entitled to apply for division of property at the termination of the cohabitation. However, on the evidence before me, the claimant, Mr. Dessado and Ms. Brown, were not only in a common law union, but had acquired the property jointly. The parties agree that the property which was acquired during their common law union and for which they are registered as joint tenants was in fact referred to as the family home. The circumstances would therefore bring the application by the claimant, that's Mr. Dessado, within the provisions of the Property Rights of Spouses Act. Therefore, at this interlocutory stage, strange word again, unusual word, what is to be determined is whether the court should allow the claim to continue. Section 13, subsection 2 does not set out the criteria for making a determination whether to grant an extension of time, except to say that an application for extension of time shall be made within 12 months of such longer time as allowed by the court. The decision of Delkialin versus Trevor Mesquatia, 2011, confirms it is one of for the exercise of judicial discretion. Harris J.A. in Allen versus Mesquita stated in paragraph 26 that a court, in deciding whether a limitation period should take effect, is under an obligation to consider the circumstances of the particular case, taking into account whether there is any good reason which would prevail against the statute operating. So here, again, make sure at the end of your common law union, you apply to the court within 12 months, before 12 months come, for anything that you might be entitled to. Now, in this other case, it states here, in seeking an extension of time to file his claim, an applicant must also seek leave to extend the time and place before the court reasons to be evaluated by the court to justify his right to do so. So you would have to apply for extension of time and supply reasons why you should get that extension of time. You have to go through all of that trouble if you wait for too long. I will continue reading. Unless there is a good reason not to do so, the court's starting point then should be in favor of the defense when it is raised that benefit which occurred to the defendant should only be taken away on good reason being shown. So you have to have a good reason for that extension of time. If you wait more than a year, more than 12 months, it may be assumed, it may be seen as you're abandoning any interest you have in the property. You must apply within 12 months. All right? Guidance as to how one makes a determination as to what constitutes good reason is set out in Brown versus Brown. Morrison J.A. said, on the application under Section 13, subsection 2, it seems to me that all the judge is required to consider is whether it will be fair, particularly to the proposed defendant, but also to the proposed claimant, to allow the application to be made out of time, taken into account the usual factors relevant to the exercise of a discretion to this sort, such as the merit of the case, on purely prima facie basis, on the face of it basis, delay, prejudice, and overriding objective of enabling the court to deal with matters justly. Prima facie case. On the evidence, it is beyond clear that in 2002, Mr. Dessado had a prima facie claim to an interest and very likely have been able to establish an equal share in the property, which he asserts was the family home. That's what would happen if he brought the case in 2002, the same year. Alright? If he had brought the case in 2002, it would be a clear case. He would be entitled to half the share in the property. Right? Reliance is placed on the decision of Sykes, J, I guess that would be Justice Sykes, in the case, in this particular case, in 1996, in determining whether the claimant had a prima facie case. The learned judge found that the claimant had a prima facie case under the normal principles of equity and the limitation defense under the property rights of spouses act would not prevent a claim in equity. At paragraph 24 of the judgment, Sykes J states, in this case, there is no doubt that Miss Smith had a prima facie case to an interest in the property. Her name is on the title, and at present there is nothing to suggest that her name was placed on the title for any reason other than to give her an interest. Now for the delay. The case law in the point of extension of time under the Property Rights of Spouses Act suggests that 18 years delay in making the application to claim an interest in the family home is inordinate. In Smith versus Service, Teen versus Wiltshire, the court found that 14 years was inordinately long. And in this other decision, a delay of 9 years was held to be inordinately long in each case. However, the decision of Davin versus Davin recognizes that delay in and of itself is not a bar to a claimant's making an application under the Property Rights of Spouses Act. Now here, let me just pause. You see, 9 years, 18 years, it might be assumed, that you have abandoned your interest in the property. If you wanted any interest in the property, you should have applied before the 1 year period. So take that as a warning, or there will be a lot more trouble for you. Even though the court can still consider your case, but you'll have to do a lot more work in justifying why the court should do so. But let's continue. In that case, it was also held that a claim to a legal and equitable interest may be allowed, notwithstanding an inordinate delay, where there is a reasonable explanation for the delay. In the decision of Smith versus Service and the decision of Natalie 10 versus Wayne Anthony Wiltshire, the court in each case found the equity in property arose from the fact that the claimant, the person who applied, was a registered proprietor. In Smith versus Service, notwithstanding the delay of 15 years, it was determined that there was a case to which the respondent should answer. After 18 years, the names of the claimant and the defendant remain on the title, which was acquired by both parties. At the termination of the union, both the claimant and the defendant each had a half share in the family home. I am of the view that given the circumstances, the delay in and of itself in this context is not a bar to making the application for an extension of time under section 13 subsection 1 of the Property Rights of Spouses Act. Prejudice consideration is to be given as to the likely prejudice in allowing the extension of time. It is submitted by counsel for the defendant that she would suffer prejudice as the claimant's right has been exhausted by virtue of the Limitations of Actions Act. It was submitted further that granting an extension of time would prevent the claimant's interest being defeated by a possessory title. So here, his name is still on the title. So you don't want to throw out the case and say that he has no interest in the property when the title clearly shows his name on it. That seems to be what that is saying. Natalie 10 versus Wayne Winshire 2020 concerned an application to extend time under the Property Rights of Spouses Act. In this case, the application was in respect of the matrimonial property. It was submitted on behalf of the respondent that to allow the application would automatically deny the claim he wished to make and that he had adversely possessed any interest the applicant had in the property. Barnaby J. AG, as she then was held in that case that the Limitations of Action Act provided a defense which the respondent could assert in answer. Barnaby J. at paragraph 21 in her analysis stated, furthermore, I do not believe that a claim for adverse possessory title through adverse possession would be lost to a respondent on the claim for division of the matrimonial home under the Property Rights of Spouses Act. So here she does not believe that if you have lived at the property for a long time, having adverse possession and getting an adverse possessory title through adverse possession, that a claim would be lost to a respondent on the claim for division. A claim for adverse possessory title. You're applying for the title, and that claim would be lost to a respondent on the claim for division of the property. So it seems to be saying that even if you apply and receive a title based on your adverse possession, the other person who had interest in the title, it doesn't mean that that person would have lost all interest. Seems to be what that is saying. A paragraph in our conclusion stated, there would be no significant prejudice to the respondent if the claim is allowed to be made at this time, thereby enabling the court to deal justly with the disputed matters, including any issue as to possessory acquisition of the applicant's share in the property since the dissolution of marriage. I adopt the statement of law by Barnaby J. to say that in the circumstances of this case, I do not agree that the defendant, Ms. Brown, will suffer prejudice if I allow the extension of time. The defendant, Ms. Brown, can, at the appropriate stage, invoke a defense under the Limitation of Actions Act and claim a possessory title. So she herself could claim a title to the property because of how long she has been there undisturbed. The court will then determine the legal and factual issues. At this stage, what is to be determined is whether there is a prima facie basis to the claim or if there is merit in the claim. I am not required to make any findings of fact one way or the other, as I have not done so, and I have not done so. All right. Now we look at the overriding objective in dealing with cases justly and looking at the ruling in the next video.